Greetings, everyone. My name is Jonathan Bailey. I am from the website Plagiarism Today, which can be found at plagiarismtoday.com. I'm a copyright and plagiarism expert with 18 years of experience in the field. And if you think that expertise might be able to help you out some way, please do check out my consulting site at copybyte.com, copybyte.com. Learn about the various services I provide, including plagiarism analysis, expert witness work, DMCA agent and DMCA takedown services, plus much more. Once again, copybyte, copybyte.com. Well, on that note, this week we're talking about something that's extremely important, especially to those of you out there on YouTube, whether you're just someone who enjoys watching videos on YouTube, or doubly so if you're someone who uploads content to YouTube. That's because fair use in the United States is changing. It's changing in very significant ways and it's changing very rapidly right now, and it all has to do with this guy. That's right, Andy Warhol. Now, I'm sure you've likely heard about the decision involving him early last year, and we're going to be talking about that. But this is a video in three parts. First, we're going to take a look at sort of the history of fair use, or at least the current history of fair use, up to the Warhol ruling. Then we're going to talk about the Warhol ruling itself, and then we're going to take a look at a pair of decisions, or rather one decision and one settlement, that sort of explain how fair use is changing now that the Warhol ruling is on the books and courts are now basing their fair use decisions on that. So to begin with, let's start out by taking a very, very quick, and I do mean quick, primer on fair use and its modern history. All right, to begin with, we're going to start with a history lesson. And like any good history lesson, we have to choose a point to begin, and that's obviously going to be complicated here. However, I'm going to start with 1976, specifically the Copyright Act of 1976, which took effect January 1st, 1978. That was the Copyright Act that codified fair use and the four factors, which I'll be putting up on the screen here, into law. Now, the law makes it clear that all four factors are supposed to be weighed, albeit with different balances upon each, but they're all four supposed to be considered by a judge and or jury when considering a fair use. Now, we're not going to go through them one by one. As you'll see in a minute, we don't really have to. But I want to put the focus on the first and the fourth factor, as A, they are the most important, and B, they're the most relevant to our story. Those factors are the purpose and character of your use, and the effect of that use upon the potential market. In particular, the first. And by the way, this is not the actual language from the law. This is a truncated and simplified version from Stanford Libraries. I'll put a link in the description. They have a really great document about this. Now, the thing about fair use as it was codified into law is that there is a lot of flexibility and room for interpretation there. So, as you might imagine, there were a lot of legal cases about it too. And while once again, we have to choose what to leave in and put out, the main one I want to talk about today took place in 1994, and it's Campbell versus A. Cuff Rose, or as I like to refer to it as, the Pretty Woman case. Basically, Roy Orbison wrote a song called Oh Pretty Woman. You likely have heard it. And the band Two Live Crew released a parody version called Pretty Woman. And if you know anything about Two Live Crew, you know what kind of parody it is and why I'm just going to dance away from that topic on YouTube. This case went back and forth. The lower court actually sided with Two Live Crew, saying that the parody was a protected fair use. The appeals court reversed that and remanded it, siding with Orbison. But then it went to the Supreme Court, which actually handed down a very, very nuanced decision, discussing whether or not this parody was a protected fair use. And essentially, what the ruling said is that it could be a fair use. It doesn't actually say definitely that it is. It actually remands it to the lower court for it to be dealt with, but it does say that it could be. However, there is one line in this that is obviously going to be the most important for a long time to come, and that is this one. The Supreme Court said, and I quote, "The more transformative the new work, the less will be the significance of the other factors like commercialism that may weigh against the finding of fair use." Now that's, once again, a pretty nuanced position. And as someone who's sitting next to MST3K stuff, and I know it's not on camera, but I have the Weird Al Yankovic accordion box set above me, I do like a good parody or two, even though both of them ask permission, but that's neither here nor there. The point of the matter is, I actually did like this outcome. I think it was the right choice. However, and this is going to become a theme as we move forward, how that ruling was interpreted became more of the sticking point, because that one line I just read to you about transformativeness, that ended up being what lower courts really latched onto and really heard. And over the decades that followed, the now nearly 3 decades, courts began to look either exclusively or almost exclusively at how transformative a work was, ignoring other parts of the first factor and the other factors altogether. And this led to some pretty interesting decisions. One such example of a very controversial verdict involved the artist Richard Prince, who, by the way, I will be using his full name through all this for reasons that'll become clear in a second. But Richard Prince and the photographer Patrick Carew. I have no idea if that's actually how you say his name, by the way. But, anyways, the photographer in this case took a bunch of photos of Rastafarians in Jamaica and released it as part of a photo book. Richard Prince, a self described appropriation artist, took those photos and then drew little squiggles on them, put guitars in their hands, did a variety of things that he said was changing the message and was creating new art, basically. And the result of that was Carew sued Richard Prince for copyright infringement. This time around, the lower court sided with the photographer, but the appeals court ended up more or less siding with Richard Prince, ruling that on the vast majority of the images, it was a clear, fair use. And the result of that was the case was remanded back to the lower court. The two sides hashed out a settlement on the remaining photos, and the case ended. However, photographers in particular were very upset because they saw what Richard Prince did with the images as a very egregious copyright infringement and worried that this could discourage pretty much all licensing of photographs. Now, that didn't necessarily come to fruition, but for 10 years there, this was probably the fair use decision most in front of mind for visual artists in particular, just because no matter which side you were on, it was a very decisive statement. They ruled, quite simply, that since Richard Prince's work was quote unquote transformative, that it was immediately not infringing and it was a fair use. And like I said, only some of the photographs were ruled not to be transformative enough. However, that now brings us up to the Warhol ruling and, well, we'll just say the very busy early months of 2023. So at this point in our history lesson, fair use has been codified in law since 1978, so we're getting about 45 years there. And for the last 30 years there, the conversation around fair use, at least among judges and juries, has been almost solely around transformativeness and how transformative a use is. Well, that all changes in May 2023. Now, the story here actually begins in 1981. That was when photographer Lynn Goldsmith, a very famous celebrity photographer, took a photo of the musician Prince. And now you can see why the Prince thing was going to get confusing. Anyways, she was doing that as part of an assignment for Newsweek, but she retained the copyright in the photographs. In 1984, she then licensed that photo to Vanity Fair so that Vanity Fair could contract Andy Warhol, the very famous painter, to basically make a painting out of it that would then be featured on the cover of Vanity Fair, which is exactly what Warhol did, a very famous Prince painting you're probably very familiar with. However, what was less known at the time was that Andy Warhol made multiple versions of that painting in different colors with different changes, and that's not necessarily unexpected. I would obviously expect a professional artist like this to make multiple drafts of something and pick what they like the best to submit. Now, Andy Warhol himself passed away in 1987. The copyright in his work transferred to the Andy Warhol Foundation, the AWF, what I'll be referring to as the Warhol Estate moving forward. All in all, not much happened until April 2016, which is when the musician Prince also passed away. And then apparently what happened here is that the Andy Warhol Foundation informed Vanity Fair, hey, we found or have all these additional paintings that Warhol made at the same time. Would you like to license one of them? And they chose to and published it. Now, one thing that's very important to note here is that even though Lynn Goldsmith is the alleged infringed party, she did not actually file the lawsuit. She simply raised objections over the use of the photo in such a way, and the Warhol Foundation, the estate, sued her. This is why they are listed in the plaintiff line of the lawsuit. And to be clear, even though Lynn Goldsmith is not an impoverished person, she's doing very well for herself, this case was still a financial burden on her. She had to sell her house. She even attempted to launch a GoFundMe to help finance just some of this defense. So yeah, she really did get put through the ringer here, and she was the one who was sued, not the other way around. Regardless, the district court ended up siding with the Warhol estate, and that was overturned by the Second Circuit. However, another appeal was made to the Supreme Court, then ruled on this case once again in May 2023. And the result of that decision was basically that transformativeness was no longer going to be the sole word you hear about in fair use cases. The court made it abundantly clear that transformativeness is just part of the first factor of fair use. It doesn't actually cover the entirety of the first factor, let alone all four factors. So, yes, while transformativeness was important, basically it said that it is not everything about a fair use case. And part of that was they looked at how the photo was used. They didn't look so close at the work itself. Instead, they looked at the fact that it was licensed to Vanity Fair and then used to represent the musician Prince, which is exactly what the photograph was intended to do. So that was a big part of that decision. In short, even though Warhol had added new creative expression by creating a painting based upon the photo, that was not enough for this use to not be an infringement of the original photograph. And with that, transformativeness, while still theoretically a very important part of a fair use discussion, was no longer going to be the king of the fair use conversation. And that's what we've been seeing moving forward. So now we have this major Supreme Court ruling that seems to be trying to put transformativeness sort of on a tighter leash than it has been for the past 3 decades. The big question that obviously comes up is, how are the lower courts going to apply it? And we have a bunch of district court rulings, but just last week we got our first appeals court ruling that leaned very heavily on the Warhol case, and I think it's one well worth examining. Now, this case involves a photographer named Larry Philpott, who in July 2013 took a photo of musician Ted Nugent at a concert. He registered the work with the U.S. Copyright Office, but also uploaded it to Wikimedia Commons for others to use under a Creative Commons license. In March 2016, the publication, the Independent Journal Review, used the photo as part of a listicle article they were publishing. However, they failed to complete the attribution requirement of the Creative Commons license. Seriously, y'all, go check out my article about how to legally use photos from Wikimedia Commons, and also my other article about how to correctly use Creative Commons works. It can save you a lot of headache. But regardless, since they failed to complete the attribution requirement, Philpott filed the lawsuit. However, in August 2021, the lower court found in favor of the Independent Journal Review. They found that since it was being used as part of this article and had a different purpose and different meaning behind it, that it was transformative and thus a fair use. Well, Philpott appealed, and that case was heard in October 2023. Now, those playing along at home might note that the Warhol ruling falls pretty much smack between those two things. So, when they went before the Fourth Circuit in October 2023, the Warhol ruling was on everyone's mind. And the Fourth Circuit ended up completely reversing the lower court decision, where the lower court found that IJR's use was a fair use as a matter of law. The appeals court completely flipped the script, finding that it was not a fair use as a matter of law. And that ruling cited Warhol 10 separate times, which is pretty wild. I mean, the Pretty Woman case it cited 8 times, but usually to contradict when they were citing Warhol. It's a very, very extreme case of a court heavily citing a brand new verdict that doesn't have a lot of case law behind it yet. However, what I think is the most damning quote from this decision is this one. Like the magazine's use of the orange prints in Warhol, IJR's use of the photo was not transformative. Here, as in Warhol, Philpott took the photo to capture a portrait of Ted Nugent, and IJR used the photo to depict the musician. Accordingly, the two uses shared substantially the same purpose. Indeed, IJR has less of a case for transformative use than the Andy Warhol Foundation did in Warhol. Unlike the orange dubbing in that case, IJR did not alter or add new expression to the Nugent photo beyond cropping the negative space. As a result of that, the court sided with the photographer, ruling that it was not a fair use and remanding the case back to the lower court where it will be heard now. Needless to say, that is a complete reversal of fortune, and I would expect to see a lot more cases like this one where a decision that was reached pre-Warhol cannot be replicated post-Warhol. And I'm not the only one that seems to be thinking that way. Remember Richard Prince? We discussed him earlier in this video. Well, in a very similar-ish case involving another series he did of Instagram photos, he opted to settle, or largely settle, a case against 2 photographers who had sued him for copyright infringement in that. Where pre-Warhol we had proved he was perfectly willing and able to fight and win these fair use decisions, here he felt so unconfident in his position that not only did he agree to settle the case, he agreed to pay 5x the sale price of these paintings as damages. It's a pretty significant reversal of fortune for Richard Prince, too. So, yeah. That's what's changing. This idea of transformativeness is on a leash now. It's no longer the sole factor that's being weighed when it comes to fair use. In fact, it's not the sole factor being weighed in the first factor of fair use anymore. And furthermore, courts are now looking more at how the two works are being used, whether they're being used to fill the same function, rather than the artistic merit or whether these two works are different in meaning or scope or something else. They're looking at the more practical, how these works are being used to determine the actual level of transformativeness, bringing more of that fourth factor in, which looks at the potential harm for the market of the work. An interesting comparison here is that when the lower court actually ruled on the Ted Nugent photo case I just talked about, they didn't even do an analysis of the second and third factors of fair use. They only looked at the first and briefly touched on the fourth. The appeals court went through all four and came to the exact opposite decision in a post-Warhol world. So that's what I'm expecting to see. We're going to see a fair use landscape that is more uncertain for people who are making use of other works and relying on a fair use defense, and one that's going to depend upon a multitude of factors, not just transformativeness. And as I wrote in an article, I'll put it in the description once again, this could be very bad news for AI companies who have very heavily leaned on this idea of transformativeness to justify why their use of copyright protected content to train AI systems is not an infringement. However, that is a whole other long video. I'm going to leave it there for right now. Well, on that note, everyone, thank you very much for joining me for this past video. Please do like and subscribe. I hope that this was useful. I do feel that this was an extremely important topic, especially here on YouTube, where so much of the fair use debate, discussion, and unfortunately likely litigation is going on right now. Once again, though, my name is Jonathan Bailey. I'm from the site Plagiarism Today, which can be found at plagiarismtoday.com. Also, please do check out my consulting site if you think my expertise can help you at copybyte.com, COPYBYTE.com. Until next time, this is Jonathan Bailey, signing off.